Welcome to Real Estate of Mind, a Farming Group podcast. Welcome to another edition of Real Estate of Mind. Today I have the good fortune to be here with two of the world's greatest litigators, Mike Jacobson and David Williams from Jaffe Law. Gentlemen, welcome.
Thank you, Andy.
Always good to see you, Andy.
So guys, I was talking to a number of people in our firm this week, and they were all excited that you're coming over. Obviously, you're here in our studios today. Such an exciting time. But, the topic of litigation is obviously something that brings fear to a lot of people. It's something we all try to avoid, or at least most people try to avoid litigation. Some make a career of litigation other than the attorneys. And I know there's a number of topics that are probably hot topics right now that you think might be most interesting to our listeners, how to avoid litigation, areas that they can be aware of. Mike, why don't we start with you? Tell us something that you think right now is an area that's just a hot topic in your world.
Well, Andy, I think you make a great point that most people want to avoid litigation. And David and I sort of have made a career of not only litigating cases, but counseling clients on how to avoid litigation and the pitfalls of litigation. Because once you get into litigation, while we live it every day, it takes away from your everyday job as a client. It weighs on your mind, and it seldom results in victory unless you can actually go to trial and win. So avoiding litigation is actually a good thing, and I know that's unusual coming from a litigator. I would tell you one of the hottest things I've seen, especially in this hot real estate market, is what I call buyers beware of seller's remorse. And what I mean by that is now sellers will put their properties up for sale, they'll list it, they'll engage brokers such as yourself and other brokers, and they will get a deal signed up, and all of a sudden they realize, well, 2 months after, the market has continued to improve and stay hot, or have gotten hotter, and they want to back out of a deal. And I've happened to be involved in several of these litigations recently, and when I say buyers beware of seller's remorse, what sellers are doing are using straw men, or they're using so-called agents to sign purchase agreements. And as a buyer, you think you have a deal, and then when you get further along towards closing, the seller says, well, I'm backing out. I don't want to do the deal anymore. And the buyer says, well, we have a signed purchase agreement. We have a signed contract. And what sellers are doing are saying, actually, I never agreed to that contract. That was my lawyer who signed the contract, or that was someone else who signed my name to the contract. And what happens is the buyer is forced, if they still want the property, to go to court and make claims that they have a binding contract. And sellers, their defense, or what they try and do, is say, we did not give authority to have that signed on our behalf. So as a buyer, when you're executing a purchase agreement, you want to make sure the seller has authority to enter into that purchase agreement. If you're entering into a purchase agreement with a corporation, you want to see the corporate resolutions or some type of binding agreement that allows the signator to bind the corporation. And especially in single asset corporations where the seller says, oh, what's the worst that can happen? I can lose my single asset or
Right.
something like that. The other thing, an attorney signing on behalf of a seller, that attorney needs a specific power of attorney in which to be able to bind the seller. And that gets into real estate contracts specifically that need to be signed by the person to be bound. And what I've seen sellers doing is saying, well, I told my attorney they could sign it, and then falling back in the litigation and saying, well, me telling the attorney to sign it, there's no writing between us, so because there's no writing, there's no binding contract, and that gets into a legal term called statute of frauds. And you want to, as a buyer, you want to protect against that. And I'm not giving ourselves a plug, but you should have an attorney always review a purchase agreement and review the authority that the signer for the seller has in order to sign for that property to be sold.
It is important, absolutely.
So that has become a really hot area of litigation in real estate, especially now that real estate is trading so often and so quickly, and deals are getting done within the fastest time they've ever gotten done. And it's something to avoid. You can avoid as a buyer if before you enter the deal and before that purchase agreement is signed, you actually see all the documents granting the seller's signer the authority to bind the seller.
That's good to know. And you talk about the hot market. It really has affected a seller's, the day after they sign an agreement, they get another offer that's for far more, and another the next day, and they start rethinking that. Like, did I sell it too inexpensively? I've never seen anyone, in the clients that we've worked with, try to back out of a deal to that extent, but I would imagine that opens them up to a whole lot. And let me ask you this, because you raised an interesting point with, if an attorney signs your purchase agreement on your behalf, and then you, as the seller, back out of that, does that leave exposure for the attorney who signed it? I mean, what ultimately happens with that?
Yes, actually, in real estate, it's very difficult when you don't have a signed contract by the people who actually are to be bound. So when the attorney signs it on behalf of a client, or even signs the client's name on behalf of that client, the attorney opens themselves up to something what's called promissory estoppel. And that's when you don't really have a contract, but you can force, you wouldn't be able to force the sale, but you could go collect money from the attorney who signed it, because they're making a promise to you. But that doesn't afford you the right to go get that property, unless the attorney, who is now in a pinch, can go to their client and say, you got me in a real jam, so either I'm gonna have to pay the buyer to go away,
Right.
or you're gonna actually have to sell the property to the buyer.
Interesting.
So that's, I've had a real life situation just like that, and it turned out that the seller said the attorney did not have the authority to sign his name, and we put the pressure on the attorney and threatened to bring a cause of action against them, and it turned out they got their client to cave. But I will tell you, from a best practice standpoint, the attorney's office now has stopped signing contracts for their clients.
Very smart move.
So, and again, if you want to be diabolical on the other hand, which I never condone,
No
but
one
if
does.
you are a seller and you think you're going to get better offers and the market's going to be hot, of course you could sign contracts all day where you don't have authority for the corporation, or there's not a corporate resolution, and and that contract never becomes binding.
Interesting. You know, that's unfortunate that people do those types of things, and obviously that's why great attorneys like you are here to protect clients from those types of situations. What we've seen from a real estate perspective, more than people trying to leave themselves out in a diabolical way, is we're seeing more and more sellers saying, look, sign a non-disclosure agreement, we'll give you all the due diligence you want. When and if you're ready to sign a purchase agreement, you'll go hard immediately, pay your down payment, and you'll close within X number of days. And that way they keep it on the market so that they don't lose this buyer, but they don't let them have that single source of, having the property under contract. So you get them ready, but sounds like there's always some way to skirt the system. And thank God for people like you, Mike, that stop that from happening.
Well, as David and I have always said, what you just detailed is why you're such a great real estate person.
Oh, thank you. It's all the firemen's. I just sit behind a microphone here and look pretty. All right, I appreciate that. On to the tough question now with David. Well, all right, David. So I think that was an interesting topic that Mike gave us. Obviously, you're coming in just heavily armed with all the, you were engaged at any given time in any number of actions, issues. I talk to you not as often as daily, but regularly, and you are always buried in a number of different issues. So I know there's a variety of topics you could hit, but I'm sure you've got certain ones that you feel our listeners might find most interesting and most applicable.
Well, I really appreciate that. And of course, I'm always happy to talk with you. I do always have a lot of different interesting cases going on, but Mike and I do see a lot of common themes. We see certain things that seem to get people into trouble over and over and over again. And so I always try to talk to clients, as Mike said, we want to help you avoid litigation.
Right.
And there are a few things you can do that really dramatically reduce the likelihood of litigation, and particularly if you wind up in a dispute, help you avoid a bad outcome. And I think the number one thing we tell people is be careful about what you put in writing. And I always tell people, if you wouldn't want your parents or your children or your spouse or your spiritual advisor to see it, don't put it in writing.
Right.
There are a number of different areas where we see people communicating where they sometimes wander into that problem. One of the ones we see is internal criticism. So someone's having a bad day at the office and they send an email criticizing their boss to a coworker or criticizing one coworker to another coworker. This is not uncommon. People have bad days, and of course they wouldn't say that directly to the person's face and expect that no one will ever see it.
Right.
But what happens in litigation is often all of the emails from various sources will be gathered and presented to the other side. And as an employee, then you've got a double whammy. Your boss now sees the email you never thought they'd see criticizing him,
Right.
and someone on the other side is going to use that to hurt your organization.
Because emails never go away. I don't care what anyone tells you, they don't.
do not. That's exactly right. And so if you're just blowing off steam, don't put it in writing.
Right.
You know, have lunch with a colleague. I tell people, tell it to your dog. My dog's very good at not revealing the things that I tell her.
Is that a breach of client confidentiality if you tell it to the dog?
Absolutely
I'm just asking.
not.
Okay.
It's covered. It's covered. Now you have to be careful even about things that you say in public. There was a recent case in Benton Harbor where some teachers lost their jobs after talking about school business in a bar, public place, but where they didn't expect anyone was listening to them. And in fact, someone was recording them.
Wow.
And so you just always want to be aware of your surroundings and your circumstances, and just be very aware of statements you make that are critical of people that you really wouldn't want those folks to hear.
Well, everything these days is public, so I think you're right. You have to be very careful what you're talking about at any given time. You take those teachers that you're referencing were off the clock. They weren't working, but you are a part of the public when you serve at the public's behest. So I'm sure that they were surprised when they got in trouble for that. But nowadays, nothing is private anymore.
one of the other things that we've all experienced, I think, is you send a message, a text message or an email to the wrong person. And again, that's the kind of thing that can get you into serious trouble. So it's we're living in an age when everything almost is recorded or kept. Emails do exist forever. Text messages, you've got to assume, can exist forever. And there was the recent case of a guy who had a couple important text messages to send to his supposed hitman, planning to kill his wife, and sent them to his old boss.
Right.
And you can imagine that that didn't end well for him. So that's just a warning to all of us.
Right. I think that the answer to that is don't hire a hitman to begin with. That's probably the first thing.
That is absolutely.
Forget
that's
the
good
email
advice.
error he made. Probably good not to do that. Any other topics that you think might be interesting, or diving further into that particular area?
One of the things we notice, as litigators, we have the benefit of hindsight. I always say hindsight is 20/20. And oftentimes when we're going back through reams of emails, communications, voicemails, we will very clearly see a moment when a transaction, a relationship, where it went wrong, where it
Right.
went bad. And people sometimes make the mistake of getting an email or getting a voicemail that they know in their gut is a sign that something's gone wrong with the buyer, with the seller, with the client, with someone on the other side of the deal. And I always tell people, when you get that feeling in your gut, stop and ask yourself, should I escalate this?
Right.
Should I take it to my boss? Maybe even call my lawyer? I'll tell you, we do get a lot of calls from people who say, you know what, I'm not in litigation. I don't want to get into litigation.
Right.
I have a deal that I really want to get it done, but now I'm a little worried it could go south. Can you help? And we will often help clients craft a letter or an email, even one that they're going to send themselves, to help de-escalate a situation and to avoid putting things in writing that might be used against them later. So just be aware of that moment when you see a problem and try to address the problem then, or bring it to us then, rather than waiting until a few weeks later and now you really know you got a problem and it's a little harder to dig out.
Right. And I think that's, you bring about a good point. And from our experience working with you and Mike, a lot of times we do get you involved when there is no litigation, but something in the conversation or the tone of the deal structure feels off. And the one thing that I personally like, and I know that our organization appreciates, is you guys really aren't focused on, a lot of people would focus on, I've got a litigation case, I can make X per hour or whatever it is, this can feed my family for years. You guys really look at the big picture in things and say, how do we avoid litigation? How do we work in a manner that makes this issue, resolves the issue on both sides? You're never just saying it's got to be one side. And a lot of times you look at that and say, look, here's what you need to do. And I'll tell you, an issue that you dealt with, without getting into specifics, we had a lease deal that was going awry, and it was nothing that we had done, but the other side had a particular desire for things that maybe they weren't entitled to. And just by reaching out to you, you helped us de-escalate that by realizing it goes beyond the contract. First of all, how do we resolve a situation as best you can to everyone's equal, I'm going to say dissatisfaction, but also satisfaction. It's a combination. But what you were able to do was bring us together in a way that made us realize it would cost us more by simply not sitting down and trying to find common ground than it would have working together towards that common ground. And to this day, that client, I would consider we have a closeness with. That client sings your praises to everyone. You're on the opposite side of the table from that client, and they love you, and we love you for it. I mean, that was a great moment of clarity.
So, Mike and I really like to be partners with our clients. We like to be there with you from the very beginning and help before an issue gets out of control. And a lot of times we can prevent it from escalating into litigation. And that's one of the reasons both of us try to be available 24/7. If something comes up, people can call us and we can help deal with the situation in real time rather than waiting for a legal filing.
Absolutely. So David, that's a great segue, because by the time people are done listening to this, they're going to want to know, how do I get a hold of Mike Jacobson and David Williams when I have issues that I need to discuss or concerns that are out there? So for our listeners, why don't you tell us what's the best way to reach you guys?
So there are two ways. First of all, you can just call our office at Jaffe, 248-351-3000, and ask for Mike Jacobson or David Williams. The other thing you can do is you can email us. Mike is at mjacobson@jaffelaw.com. It's JAFFELAW.com. And I'm dwilliams@jaffelaw.com. Now, if you were listening, you know, when you send us an email, just give us your name and ask us to give you a call. You don't have to include all the details of your dispute. Once we have a relationship set up, everything's covered by the attorney-client privilege. But until we get that started, just let us know you want to talk.
And that's a very good point. So just like you described with email, sometimes too much is too much. So we'll make sure everyone gets that. That'll also be in writing on our website as well. Really very fortunate to have you both here today. I appreciate your time. David, Mike, thanks so much for being here. And on behalf of the Farbman Group and Real Estate of Mind, this has been Andy Gutman with Mike Jacobson and David Williams of Jaffe Law. Have a great and productive day. Join us next time for another wonderful edition of Real Estate of Mind, a Farbman Group podcast.